This one I wanted to do the other day. What have I had? 12 lawyers so far? 12 of them? 12 stupid attorneys. And all the research I do comes back to this case, Gideon versus Wainwright. So it said, please summarize the case of Gideon versus Wainwright. Gideon versus Wainwright is a landmark decision. Landmark. It's a fundamental cornerstone of the American justice system. A very landmark. From 1963. The United States Supreme Court established the constitutional rights to legal counsel for criminal defendants in state courts. Clarence Earl Gideon, breaking and entering, couldn't afford an attorney and requested the court appoint one for him. Trial court denied his request, saying that under Florida law, counsel is only appointed in capital cases. He represented himself at trial, and he was convicted. You don't stand any chance in these courts. None. Because they're not real courts. Not at all. It's a legal question. Does the Sixth Amendment right to counsel, as applied to the 14th Amendment due process clause, require states to provide legal counsel to defense in criminal cases who cannot afford one? Unanimous opinion. Court held the right to counsel is a fundamental right essential to a fair trial under the Sixth Amendment. Skip to us. They overturned Betts versus Brady. Back in the 40s, we got UFOs and frickin' UFOs flying around in Nazi Deglakas. You don't get a lawyer. You don't get some $300 an hour lawyer. So yeah, anyway, after the ruling, Gideon was retried, so he got double jeopardy with the assistance of court-appointed attorney and was acquitted. So he got the Pamber Smatwell of his day, or that stripper lawyer had, whatever her name was, and he won. It's a cornerstone. So I said, what would be an exception to this ruling that would disqualify a criminal defendant from being appointed an attorney, granted the fact that Gideon versus Wainwright guarantees one? So it says, while Gideon versus Wainwright guarantees the right to legal counsel over criminal defense who cannot afford an attorney, there are specific circumstances where a defendant may not qualify for court-appointed counsel. So if it's non-criminal, no risk of jail or prison, if you waive your right, if you make enough money, misuse or abuse of court-appointed attorneys. This is what I think they're going for. Even though I've told the courts that these attorneys, the courts, everyone's getting anonymous berating and threatening phone calls. They're not from me. So I think this is what they're not saying it, but I know this is what they're doing. Court might deny appointing new counsel if the defendant repeatedly fires or refuses to work with appointed attorneys. And you're seeing the people that pay attention in my comment section. Oh, you're hard to work with. You're a difficult person. Never mind all these crazy anonymous phone calls being made. My mother's got people talking about hitmen and stuff. It's wild. Competency issues, they already tried that. They tried to do the incompetent to stand trial thing. They've tried that. None of these other things apply. I don't make the income. I didn't waive my right. I've asserted my right. Definitely can go to jail for this. It's definitely criminal. They've tried competency. That didn't work. They're not saying this yet, the misuse or abuse, but that's what they're going for. I know it. So it said focus on the misuse or abuse of court-appointed attorneys. What facts and evidence would be needed to accuse a defendant of misusing attorneys? You also say the defendant may be engaging in behavior to obstruct proceedings. Please elaborate. Accusing a defendant of misusing or abusing court-appointed attorneys requires clear evidence that their behavior consistently disrupts the legal process, undermines the attorney-client relationship, or intentionally obstructs proceedings. Courts are cautious when making such determinations because denying counsel implicates the defendant's constitutional rights. But the last stripper lawyer said I threatened her. I never threatened you. And thank God I recorded that. And she said, no, we got anonymous phone calls, and it's something on our live stream, and her live stream's not up. All my live streams are up. Never threatened her. So yeah, pattern of dismissing attorneys without cause. But they'll dismiss me. Courts typically look for a history of multiple attorney withdrawals, especially if the defendant cannot substantiate claims of incompetence or misconduct. I've only filed one bar complaint so far, and I should file 12 of them. frivolous complaints against attorneys. The only one I filed a bar complaint against was Pamber. And she's proven to be on drugs, proven to have mental health issues, proven to abuse her kids, or she's claimed to have abused her kids, but there's evidence of drug use, brain injuries, all that shit. Except claiming bias, conflict of interest, or poor representation, refusal to cooperate with attorneys. They won't even answer the phone. Ignoring attorney advice, like to go directly to jail. The last one, what was her name? Marie Louise Mabry. So you could take care of the warrant. And she never answered me on that, but I assume it means just go to jail. Disruptive or abusive behavior, probably like the anonymous phone calls, manipulation of the system, using attorney withdrawals to delay proceedings indefinitely. I definitely have done that. Today is the second time I've demanded a speedy trial. It's been 50 days since the last time I did it. So they have lapsed in their time. So I have to file something tomorrow. But this is a landmark decision. I'm entitled to an attorney. The 6th and 14th Amendment. You got all these people out here voting. All these voters watching my channel. I'm showing you. I'm being investigated over my First Amendment rights to free speech. I'm being denied 6th and 14th Amendment right to counsel and due process. Let's talk about delay tactics, frivolous legal motions, rejection of alternative solutions, non-appearance, failure to appear, repeated failure to appear in court or comply with procedure requirements. They won't let me appear there. Unreasonable demands. How courts respond. The court conducts a hearing to determine the defendant's actions are deliberate attempts. But they haven't flat out come out and said this yet. But I know that's the only other thing they can go for. Forcing the defendant to proceed pro se. Like, they try to claim I was incompetent. Like, not even competent to stand trial. Twice. They tried to claim that. And now they're going to force me to proceed pro se? Because you can't get an answer out of these people. Every time I call the court, they never call you back. They don't look at any of my motions. Limiting further motions or counsel. But courts must balance the need for ensure fair proceedings with the protection of constitutional rights. Denial of appointed counsel is a serious action and requires clear evidence of deliberate misconduct or abuse by the defendant. The court must document the findings thoroughly. But I'm sure you're well aware that I've had 12 court-appointed attorneys that have all withdrawn, period. They've cited, I was voice to speech in this, period just means, let's put a period on the end of it. They've said such things as conflict of interest, but have never specified them. Irreconcilable differences, but never specified them. Also, I'm aware that many of my attorneys have received anonymous phone calls threatening them. I brought this up in the courts and they've ignored this. I also filed a court case in the past which was thrown in the garbage considering a stalker I had that was making multiple anonymous phone calls about me, and the court refused to address this. I have evidence and testimony from these attorneys stating that they've received anonymous phone calls, which I believe is obstruction of justice. I believe they use this against me. Please advise. It's critical to address this situation strategically. And I am tired. And they know it. They're trying to wear me down. But yeah, it involves serious allegations that can impact both you and your defense in the integrity of the proceedings. Here's how you can approach everything. Document everything, I've done that. Motion in the court, I've done that. Request hearing, I've done that. Seek judicial accountability. I've contacted the Judicial Qualification Committee. You'll never hear back from them. Raise the issue in higher courts. I appealed my last case, and they upheld the decision that I didn't even attend a trial. I didn't get anything I asked for, according to law. Protect your rights. The only thing you do to protect your rights is just get out of the state. Emphasize these threats compromise your 14th Amendment right to due process. Yep, done that. Argue the court's failure to address these issues has exacerbated the problem. Create an environment hostile to your offense. I've argued that. They don't listen. Strengthen your arguments against potential accusations. Point out what these attorneys did. Tell them about the anonymous phone calls. How you're a victim. They don't care. External reporting. So it says, the state's judicial oversight body. Contact them. The Judicial Qualifications Committee. I messaged them, emailed them 2 months ago, if not 3. Department of Justice, anyone that's been following me knows I've reported all that mortgage fraud to them. They said, they laughed at me. She wouldn't give me her name, hung up. So I had to call the FBI. You can't get a hold of the FBI. because they need to be referred. You need like a referral, like your doctor, to get to the Department of Justice from the FBI. Fought for protective measures. Request the court to investigate and identify the source of the anonymous calls. I did that. And I especially did it. My mother said she was getting anonymous phone calls. I said, my mother / my trustee says she's receiving anonymous phone calls, threatening her life. You should look at that. They act like they didn't even, like it was never mentioned. Ask for protective orders, just like the one they threw in the garbage for my stalker. Doesn't work. The court continues to ignore your concerns. It strengthens your argument for appeals or federal intervention. It sounds like I need a lawyer, and I can't get one. Given the court's repeated refusal to respond to your motions or requests for a successor counsel, you're facing a potential violation of your Sixth Amendment right to counsel and your 14th Amendment right to due process and equal protection of the law. It's not potential, it's an absolute violation of those rights. Fought for a renewed motion of appointment of counsel. I did that. Made those arguments. Include evidence of prejudice. Done that. Request court intervention to the writ of mandamus. I haven't done that because they don't look at anything else, so why bother with that? File a complaint judicial oversight committee. Done that. Consider federal intervention. So they want me to file a 42 U.S.C. 1983 suit, which I'm going to have to do eventually. So I might as well get going on that. But who's going to look at that? I can't even win a small claims court case. Just looking for documents with my name on it. They wouldn't give me that. Because when you're targeted, you get cut off from all this shit. Second-class citizen, disenfranchised, Constitution don't apply to me. Emphasize harm caused. Consider representing yourself temporarily pro se. Document every interaction. And then they'll try to hit you up for freaking. They'll try to get you for felonies for recording this shit. In making a record. Prepare for appeals. The last time, that went so well. Court's failure to appoint successor counsel is a severe breach of your rights. It's making a declarative statement. This machine, this demon. It says it is a severe breach of my rights. By continuing to file motions, pursuing higher court for relief, and documenting these violations, you create a strong record. And that's all I can do at this point, is create a strong record. It's pointless to file the same motions. I've filed them multiple times. I've also contacted the Judicial Oversight Committee. I've received no response. So yeah, it says go to federal court. I've appealed to federal court. I actually have done that. They ignored it. Petition for writ of habeas corpus. I'll probably have to do that. It's not going to make a difference. It's a waste of time. It's a road to nowhere. Department of Justice, media advocacy organizations. They don't care. They don't care about any of this shit. Draft an open letter to the judge. That idiot can't even read. He refuses to read. Preserve evidence. That's all we're going to do, right? Is preserve evidence. But this goes on and on and on. Oh. It says your frustration is valid, but every action you take builds a stronger record for federal intervention in the future. But I say, you mentioned the courts in action, and the lengthy delays qualifier construe an unconstitutional detainment, and they have. I feel this is extrajudicial punishment. I do feel like I'm being detained. Can we discuss this aspect more? Certainly, the concept of extrajudicial punishment and what effectively constitutes unconstitutional detainment can be explored in your situation. It's been almost 3 years now. I've been detained for 3 years. So because the definition of extrajudicial punishment, legal limbo. This is by living in legal limbo. And I have the email, and I've shown that to the court, that Attorney 12 said, oh, you're in limbo. The case is in limbo. And it certainly is. It's in limbo. Forcing you to endure the burdens of legal uncertainty, homelessness, and restricted freedom. Example, fear of return to Florida due to capias. Constructive detention. This occurs when circumstances are imposed by the state amount to restriction of liberty, even if they're not physically incarcerated. In your case, the active capias warrant the no-contact order, the necessity to live in your vehicle due to constructive eviction, all contribute to a de facto restriction of your freedom. But this thing knows what it's talking about. And once again, I knew what I was talking about before I asked it. This goes on and on and on. But people are voting and thinking this is a free country. It's clearly not. We have been deemed 13th Amendment slaves. At least I have, and I know other people have as well. I'm going to leave it at this. Is 15 minutes long. But yeah, remedies, there's no remedy. These courts, where there's a controversy, there must be a remedy. And these courts are there to referee and provide and mediate a remedy, and they won't do it. They're just out to get you. The court, the prosecutor, the cops, all out to get you. Even the defense attorneys, out to get you if they don't like you. If you pissed off the wrong people, strictly for the fact of being born.